Welcome to today's program titled ERISA Litigation, 2022 Retrospective and Anticipated 2023 Developments. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP, for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Ian Morrison. Ian, please go ahead.
Thanks, Kate. And if you go to the next slide, I'll introduce our panel of presenters for today. I'm very delighted to appear with Kathleen and Jules. Briefly about us, Kathleen and I co-chair the Seyfarth Shaw ERISA and Employee Benefits Litigation practice. I am located in Chicago. Kathleen is in San Francisco, and we are delighted to be joined today by Jules Levinson, who is an associate in our group, also resident in Chicago. Kathleen and Jules have a wealth of knowledge and expertise in this area, and I'm delighted to have the chance to share the stage with them. If we could go to the next slide, we'll cover briefly the agenda. We're going to try and kind of recap what happened in 2022 and give you some projections and predictions for what may unfold in 2023. Also, if you follow the news at all, you know that that's sort of a moving target. So no guarantees. So we're going to talk a little bit about what's happening in the world of defined contribution class action cases after the Supreme Court's decision in Hughes. Then we'll talk a little bit about the effect on employee benefit plan sponsors and administrators of DOBs and some of the pitfalls that we think may unfold or develop. We'll talk about some developments in the area of ERISA choice of forum and some of the consequences of choices of forum. A lot of the unfolding law is very forum specific, at least at the moment. So there's some things to keep in mind. Importance of clear plan records and litigation around those has continued to be something in the forefront in ERISA litigation, and then withdrawal liability is something that never really goes away. So we'll cover some current developments in that area, and then a grab bag of additional topics at the very end. If you have questions throughout the presentation, feel free to put those in the chat or Q&A box, and we'll try and address them as we go through. If we don't get to your question, we'll try and address it after the presentation separately. And with that, I will hand it over to Jules to talk about defined contribution litigation.
Thanks, Ian. Next slide, please. As many of you are aware, class actions attacking various plan design decisions and fiduciary decisions of defined contribution plans, typically 401k, but in nonprofit space 403b, and other defined contribution plans have continued on their role over the last few years, somewhat unabated. And last year, we got a little bit of guidance, not very much, but a little bit of guidance from the Supreme Court on the standards for those plans. And we've seen some development after the Supreme Court's decision in how those standards are going to apply going forward. And hopefully we'll be seeing some more guidance from lower courts because, At the moment, there's some ambiguity and lack of clarity, I suppose, is the best ways of putting it, as to how courts look at and how fiduciaries should govern their behavior with respect to defined contribution plans. So the jumping off point here is Hughes, which was a Supreme Court case decided last year that came up from the Seventh Circuit. As you can see on the slide, there were participants in 403B plans that alleged they were charged excessive record-keeping fees and investment fees. And the case was initially dismissed early on by the district court, and that decision was upheld by the Seventh Circuit Court of Appeals. And a significant piece of why the courts dismissed the case and upheld the dismissal was because the Seventh Circuit had a string of decisions going back over a decade that when you were looking at the prudence of plan lineups, there was at least somewhat of a permissibility of looking holistically. So if a plan offered a lot of different investment options and plan participants had the option of choosing less expensive options, then the fact that there might have been some other investment options in the plan wouldn't necessarily be sufficient to state a claim for breach of fiduciary duty, even if there were allegations that the fees were too high or that there were cheaper investment options or record keeping available. Next slide, please. And as many of you are probably aware at this point, the Supreme Court looked at the Seventh Circuit standard and said, sorry, but please try again. The key holding in Hughes was that a plan can't just rely on a participant's ability to choose other investments or a participant's ability to take a course of action that avoids more expensive fees. Rather, as the Supreme Court had discussed in the Tibble case from a few years ago, as well as the other circuits have developed since then, plan fiduciaries have to look at each offering individually. So it's not enough to say, well, we offer 36 different investment options. There's some good index funds that are nice and cheap in there. Participants, if they don't want to pay expensive fees, can go into those cheap funds that have good performance record, and we can put in maybe some additional other funds with slightly less scrutiny. The Supreme Court said when you're looking at the prudence of investments, the prudence of the fees, the fiduciary has to review those individually to determine whether each and every option to participants is in fact prudent. So if you have 29 good investments and one less than good investment that a fiduciary might have determined was imprudent if they had looked at the question, that could be a problem. It's not enough to just look at the plan as a whole. But what was interesting about the Supreme Court's decision is that maybe because they weren't particularly interested in getting in all the details, or maybe because they were only focused on this particular aspect, the Supreme Court didn't actually address all of the issues in the underlying district court and Seventh Circuit opinions. As you can see on the slide, there were a multitude of claims that got dismissed the first time around. There were record-keeping fees, the use of multiple record keepers, allegations that certain of the transactions were prohibited by ERISA, and there were also claims that the plan shouldn't have included less popular investments that were concededly prudent. And the Supreme Court vacated the Seventh Circuit's dismissal, but it didn't actually do any analysis on the vast majority of the issues in the case. It was kind of like getting a piece of homework, getting returned and saying, with a big X over one section, okay, go try again. So next slide, please. There's something of a lack of clear guidance on many of the issues that were in the Seventh Circuit case, simply because the Supreme Court said, well, Seventh Circuit, you're wrong on this narrow question of law, but we're not giving you any discussion as to your analysis on any of the other questions. And one question that came up immediately after Hughes was the question of whether, well, does Hughes say that, okay, we're vacating the entire dismissal, does that mean that you can't ever have a motion to dismiss or rarely have a successful motion to dismiss on a defined contribution breach of fiduciary duty claim? Or is it do we take the Supreme Court at its word and say, well, Hughes addressed this narrow line of Seventh Circuit precedent, said it's no good, try again, but otherwise there hasn't been any impact on other circuit precedents, such as it may be. And so far, the courts of appeals that have decided the issue have been going with the latter approach and say Hughes is good for what it's decided, that you can't look at plan investments holistically in determining prudence, but whatever case precedent existed in circuits before then is still good law until the Supreme Court says otherwise. Next slide, please.
The one thing I would just jump in to add is that the Supreme Court does explicitly say in the opinion that the lower courts should apply the Twombly and Iqbal motion to dismiss standard, which to my mind overrules the Third Circuit decision in Sweden, which had said that didn't apply to ERISA cases. So I think, seems like that is now clarified. We have yet to see the Third Circuit explicitly acknowledge that point, but it's some guidance to say apply Twombly, apply Iqbal, but as Jules is about to get into, how that works out still remains unresolved.
Yes, so, and this is the slide, as you may have seen in the Q&A. These will be available after the presentation. Here's a list of some of the key cases that have been decided in the aftermath of Hughes, and courts have basically followed their prior precedent, including affirming dismissal where the precedent otherwise dictated dismissal. Next slide, please. And because the Supreme Court sent the case back to the Seventh Circuit held oral argument again on some of the open questions that Ian was just mentioning. And we don't have a decision there, but hopefully when the Seventh Circuit issues its new decision in Devane, we might have some more guidance, at least for the Seventh Circuit, for the substantive standards of fiduciary conduct and the pleading standards for a motion to dismiss. At one point, I have some skepticism whether the Seventh Circuit is going to actually end up there. At one point, one of the judges on the Seventh Circuit panel at oral argument suggested that fiduciaries would be okay with as long as they followed a sort of business judgment rule standard, where as long as they looked at all of the relevant considerations and made a reasonable decision, that wouldn't necessarily be attackable by a breach of fiduciary duty case. If that standard were to come to pass, I think that would be there would be a significant cutback in viable claims against 401k plans, given the very lenient nature of that standard for fiduciaries. But I think that the Devane case in the Seventh Circuit, potential future developments either in other circuits or at the Supreme Court are going to have a significant impact on the viability of claims alleging a breach of fiduciary duty on defined contribution plans. One thing that's also important to know is that because there's a lack of guidance now, a motion to dismiss can often turn on who the particular judge is and how that particular judge is looking at the facts of the case. So rather than having a sort of uniform standard, we're back to a position where there's circuit splits, there's splits within districts, even within the same circuit. And there's also the viability of these cases can turn somewhat on what plaintiff's counsel is bringing the case. There are plaintiff's counsel that do a better job of alleging specific facts. As Ian said, Iqbal and Twombly govern here. And if you have facts that allow an inference of imprudence and the plaintiff's counsel is good at pleading those facts, you might have a harder time getting such a case dismissed. Whereas if the plaintiff is just kind of throwing conclusory allegations at the wall, as we've seen also in the cases we've handled at times, then those cases are more likely to get dismissed regardless of these open questions.
And I would add that the real question here is what the courts generally agree that the test of prudence is mostly procedural, if not entirely procedural, meaning did the fiduciaries do the things they're supposed to do before taking a particular course of action? And lower courts have struggled with what does it take to plead that the plausibly plead the fiduciaries didn't do that. A lot of complaints sort of point at things supposedly indicating a lack of process. You know, you picked Fund X, which has really high expenses and really low performance. Therefore, you must have been acting imprudently. But to me, those two are not necessarily connected, and there's a zillion reasons why you could pick a fund that ultimately turns out to perform poorly or that costs more than other funds. And so it's, you know, argument remains that it's not enough to just plead comparator funds. And some courts have also found in ruling on motions to dismiss that the comparator funds are not really comparators at all, and dismissed cases on that ground. And we're starting to see now, I think in part in reaction to that, more and more cases being filed just attacking record-keeping fees and making what I think are unfounded, would be a polite way to put it, comparisons based on 5500s, saying that, you know, your plan is overpaying by 5 or 10 times because somebody else has 5500 that suggests they pay less. And you know, that to me, that falls in the same camp as the investment fee or performance comparisons. It's really not instructive, and it doesn't tell you anything about the process. But courts, I think, have struggled a bit more with that, and therefore we're seeing plaintiffs' lawyers decide they're going to file these lawsuits about investment or record-keeping fees only because they think they can squeak by a motion to dismiss more easily, and then force an early settlement because the cost of litigating outweighs the amount that's at issue. So further guidance will be very helpful in curtailing that trend should it continue.
Yeah, and just one last point to Ian's point about record keeping. Different courts have been more and less demanding on plaintiffs' counsel of how closely they have to plead that the record keeping that they're claiming was available is actually similar to the record keeping that was purchased by the plan in the given case. And that can, to the extent that courts are looking at those comparator questions, there's still a range of what's going forward in litigation. And with that, I think we're going to turn it over to Kathleen.
Thanks, Jules. Thanks, Ian. So I'm going to talk about the ongoing impact of Dobbs. I think, next slide, please, Kate. I think everybody on this call, all 212 of you, are aware of the Dobbs decision. This is where the Supreme Court ruled that the Constitution doesn't grant a right to abortion. It overruled Roe and Casey, and it basically returned the power of these arguments to the people and their elected representatives. We did have some dissents in that case. Next slide, Kate. So now the new standard is the rational basis review standard, which applies to laws relating to regulating abortion, and such laws must be sustained if there's a rational basis on which the legislator could have thought that would serve legitimate state interests, and a legitimate state interest could be the respect for preservation of prenatal life at all stages of development. So next slide, Kate. We had a dissent. I think that the dissent was an interesting read. It criticized as flippant and incorrect the majority's treatment of stare decisis. It pointed out that the reasoning and the ratifiers of the 14th Amendment clearly didn't understand reproductive rights, and also the ratifiers were all men. So it's the dissent calls the decision a loaded weapon pointed at other rights. So we'll see if that in fact happens. What we're going to talk about in the next slide, please, that certain states have sought or will seek, we think, to suppress employer support for abortion services. So this is under the generally aiding and abetting laws. Currently in Texas, there's a strong aiding and abetting law, and there was efforts to pass laws prohibiting employer payments for abortions. And this was a letter to Sidley Austin, a prominent law firm. Basically, the Texas House Freedom Caucus argued that they were facilitating abortions to the extent that it provided them to their participants in their employee benefit plan. And this Texas House Freedom Caucus intends to introduce legislation to prohibit any employer from paying for elective abortions or reimbursing abortion-related expenses, regardless of where the abortion occurs and regardless of the law in the jurisdiction where the abortion occurs. Obviously, next slide, there's serious problems with that. But the the issue now we're faced is that plans haven't really been challenged on this yet, as of yet. So it's sort of a wait and see, and there's potential issues. You should check your employee benefit plan to find out if there are, what you cover to the extent that you cover travel. And we think that the ERISA preemption may block certain state laws, but it may not stretch broadly, and it may not eliminate all risks in all circumstances. So that leads us to the next slide, which is a little bit of a primer on ERISA preemption and if you're providing employer travel benefits. We all know that a preemption applies to civil laws that relate to employee benefit plans and any regulation that forces plans to adopt a particular scheme of substantive coverage. We think that preemption applies to criminal laws targeting employee benefit plans and to fringe benefits which are provided by ERISA covered plan. Like I said, this preemption argument hasn't been tested in terms of employer travel benefits, so it remains to be seen because it may not apply to state or insurance banking laws, that regulations that merely talk about the cost of benefits and that potentially alter incentives. Fringe benefits may not be subject to ERISA. So again, this is an issue that's developing. Seyfarth has done a number of webinars and legal alerts on this issue. Next slide, please. Like I said, there's open issues. Does a venue selection clause ensure a more favorable jurisdiction? For instance, do you want to have your venues in California? Because there are safe haven laws where the legislator has enacted abortion rights, long-term abortion rights within their laws, and there's currently at the District of Columbia, I believe, 16 states listed below. So, I would definitely check what venue clause you have within your plan and what state you're in, obviously. And like I said, we'll be monitoring this issue heavily for our clients and for the general public. I should say, this next slide, there are no states that currently prohibit travel to another state for abortion care, and there are no current state laws that prohibit paying for expenses related to out-of-state abortion care. There have been attempts in several states to introduce legislation protecting the unborn child as a resident of the state. But I think the next slide, I bring up this case of Bigelow versus Virginia. This is an old case, but it basically reversed a criminal conviction of a publisher, largely on First Amendment grounds, but it also held that a state does not acquire power or supervision over the internal affairs of another state merely because the health and welfare of its own citizens may be affected when they travel to the state. There's other cases that are listed there, and you're going to be getting all these slides, and I'm definitely skipping over a lot of detail, but you'll get them at the end of this so you can delve into them more deeply if you'd like. The next slide, I wanted to bring up what Justice Kavanaugh wrote in the concurrence in Dobbs. And this talks about this aiding and abetting issue. But basically, I think it's clear that a state can't bar a resident from another state traveling to another state and getting an abortion. So I think that the constitutional right of travel will still prevail. And like I said, for additional resources, please check out this link, and you can sign up for alerts to the extent any of these laws change. We'll be on it, and we'll obviously be the first to market to make sure you all know about it. Ian is next going to talk about, next slide, the selection of an ERISA forum, the tips and risks based on some experience he's had in his cases. Ian? You're muted.
Somebody does that on every call, and this time. I was going to say that on the constitutional issue, if you're a diehard ERISA lawyer, you probably can count on the fingers of one hand the number of times you've dealt with a legitimate constitutional issue in your practice. The Dobbs issues certainly present a whole host of them, but I would say it was interesting. We had a case where we actually looked at First Amendment and Dormant Commerce Clause arguments having to do with a state attempt to prohibit an insurer's use of out-of-state doctors to provide paper file reviews. And so we ended up not having to litigate that issue fully in the case, but I think it's just a good reminder to think about constitutional overlays where sometimes ERISA preemption may fail you. You may be able to argue that, for example, the First Amendment in that circumstance would seem to prohibit the state interfering with somebody having a conversation about an issue. Or the Commerce Clause may prohibit a state from saying you are not allowed to talk to doctors in another state. And you can see those arguments having some traction in the abortion arena as well. So maybe we will all get to litigate constitutional issues as ERISA lawyers, which would be interesting, but perhaps more interesting for the lawyers than the clients. So on the issue of selecting forums, and the reason we sort of put this way is because there's a number of related issues that have to deal with the forum one way or another where you litigate. If we can go to the next slide, kind of the entry point is, where does ERISA let you file a lawsuit? And the courts, it's fair to say, have basically said anywhere. You know, there's some limits on that, but it's very hard to get a ERISA case thrown out of a federal court on the grounds that the plaintiff sued in an improper forum, at least where the defendant is a multi-state entity. Because that last point, where a defendant resides or may be found, covers lots and lots of possibilities for most of our clients who are present in almost all states. And probably also backdoors nationwide service of process for an international defendant. So if you have a foreign entity that's being sued on an ERISA claim, this probably permits them to get sued anywhere in the U.S. if they have adequate contacts with the U.S. So we have seen increasingly that employers have used venue provisions in their plans to their advantage to get sued where they would like to get sued, which can make a difference in terms of things like, what is the standard governing a motion to dismiss a 401k fees case? Do you want to be in the Seventh Circuit if you can justify it, rather than the Third Circuit, which historically has been more lenient? And I think most people who've looked at this issue have decided it's a good idea to have a forum clause. Most of the courts have, well, all of the circuit courts that have looked at this, including the Ninth Circuit, most recently have enforced those provisions. The Ninth Circuit in its ruling said, you know, the caveat was it had to be, the venue chosen had to be one of the permissible ERISA venues. Otherwise, you'd have a conflict between the plan and federal law. But given where a defendant may be found is one of the options, it's very broad. And district courts do apply these, even in California. The RJ case at the bottom is interesting, not merely because it enforced a venue transfer provision, saying that a plaintiff who was one of many plaintiffs suing in a multi-plan plaintiff class action had to go sue in Tennessee, but that it did it actually on a motion to dismiss. Normally, we would see these motions brought under a venue transfer motion under the general venue statute. But here the court specifically concluded that it was appropriate to rule on this issue in a 12b6 motion to dismiss. So something to think about if you have a venue provision in your plan that you've concluded I can't move to dismiss for improper venue. There's at least some authority, and the analysis in the RJ opinion kind of goes through the key cases on that point to say you can actually do this via a 12b6 motion, which is a bit more satisfying.
Ian, just one bit of inside baseball. Ian correctly notes that all of the circuit courts to consider the question have enforced plan venue provisions, but there's a bit of an asterisk there that we'll see if it matters, which is that the judge who wrote the Ninth Circuit opinion is a Sixth Circuit judge sitting by designation who was on the panel in the Sixth Circuit case. So the amount of judges who have concluded the venue provisions are actually enforceable is slightly smaller. So it's not clear whether that's going to matter going forward, but it'll be interesting to see what happens. Sorry, yeah, go back.
Sure. And next slide, please. So one of the things where issues where venue seems to matter still in ERISA cases is arbitration. I think the consensus is among the circuit courts that you can generally require arbitration of an ERISA claim. Even courts that have put some limits on that have said the fundamental precept that the FAA can require or allow enforcement of arbitration, has been accepted by those courts. But there's two areas where courts are struggling with what's the answer to the question of, is this particular case subject to arbitration? The most recent appellate court decision is the Hawkins case out of the Sixth Circuit, in which the defendant moved to compel arbitration based on individual employee arbitration agreements. There was no plan agreement, and the Sixth Circuit said that the 1132A2 claims were claims that belonged to the plan, and therefore the relevant party to agree to arbitration was the plan. The court rejected the argument that the plan sponsor, having signed the arbitration agreement with the employees, was enough to bind the plan, and said you've got to have something from the plan agreeing to arbitration. You don't have it, which is essentially what the Ninth Circuit had done previously in the USC case. The Supreme Court recently denied cert in Hawkins, so we're not going to get an answer to that question anytime soon from the court in Washington, but that is probably one of the things you've got to look at if you're going to put an arbitration provision into your plans. Is it's got to be put into the plan rather than being put into just an individual employment agreement, at least in the context of a retirement plan claim, which is where most of the action has been on this issue. The Triad case raises the other one that's been a hot subject of litigation, and that issue is whether or not you can actually curtail plan or effectively class litigation in arbitration. Outside of the ERISA context, I think it's fairly well accepted that you can put a class action waiver into your arbitration agreement and force people to arbitrate on an individual basis. Plaintiff's bar, of course, is trying to chip away at that, but let's assume that's the rule for now. In the ERISA space, the argument has been mounted successfully, at least in the Seventh Circuit so far, that you cannot force people to give up remedies that they would have that are plan-wide remedies by requiring them to arbitrate on an individual basis. And the hook that's been successful so far is the provision in Section 1109 of ERISA that says you can get relief, including removal of a fiduciary. The Seventh Circuit in the Smith case said, well, if you take that right away from somebody, you say they can't get plan-wide remedy like removal of a fiduciary, you are taking away their substantive rights, and that's not protected under the FAA. If we could go to the next slide, this was the subject of an argument just this week in the 10th Circuit. The Harrison case raises really the same question, where the district court had declined to enforce an arbitration agreement because it found the agreement violated this principle of not taking away the ability to vindicate rights. And the court there, the provision was very specific in the plan, essentially trying as best as possible to cut off the possibility of some kind of plan-wide relief or claims, and saying essentially the only thing you can do is you can bring an arbitration on your own behalf to get remedies for yourself personally, and in the context of the defined benefit plan, for your own account in the defined contribution plan, rather, for your own account in the plan. And the lower court said that takes away their ability to vindicate this right for plan-wide relief. At the argument earlier this week, it seemed as if the appellate court panel was probably going to be receptive to that view and less receptive to the plaintiff's view that, or rather to the defendant's view that these claims can be forced into arbitration. So we'll see what happens, but I think the tea leaves are suggesting at least that the 10th Circuit is likely to go the same way the 7th Circuit did in Smith. And that will leave, plan sponsors who are thinking about adopting arbitration for their retirement plans, wondering, what they're getting, because you may still be subject to some sorts of plan-wide claims in arbitration. If we go to the next slide. Another venue-specific issue is jury trial in ERISA claims. I think most people would assume, and they would be right for most situations, that there is no right to a jury trial in an ERISA case. The Second Circuit, however, has some case law, the Pereira case from 2005, which is not an ERISA case, but broadly interpreted the Great West versus Knutson case from the Supreme Court to say that unless you're going after a specific fund of money, the remedy you're seeking is not equitable, and therefore said you have a right to a jury trial. That's been picked up by lower courts in the Second Circuit, most recently in the Garthwaite case, to say that there is a right to a jury trial, at least on certain types of ERISA claims. We think that's wrong. The Cigna versus Amara case, which came out obviously after Knutson, specifically talks about the remedies that are available in these kinds of cases, and says that when those remedies, even though they may look like damages, when they're sought against a fiduciary for breaching the fiduciary's duties, they're equitable remedies. You can find that in particular in the Cigna decision's discussion about surcharge as a remedy. It seems to us to make it very clear that kind of damage remedy, even though it looks very much the same as damages, in this context is equitable. And so no jury trial right. Next slide. Another pitfall having to do with arbitration, we now have one circuit court decision in the ERISA context, the Hirsch decision, that's applied Badgerow from the Supreme Court to basically say, if you have a situation where you have successfully gotten into arbitration, and here there were several hundred individual arbitrations about plan investments and plan fees, those arbitration awards have to be enforced, if at all, in state court. The court there found no federal question jurisdiction, declining for the Supreme Court to sort of look through and say these are in substance ERISA claims, and then found no diversity jurisdiction in almost all of the cases because both sides of the V were Missouri citizens. So further thing to think about if you're evaluating arbitration is, if you're successful in getting a case to arbitration and there's a decision, where's the validity of that decision going to be enforced? Next slide, please. And I think that takes us back to Jules to talk a little bit about plan records.
Thanks, Ian. And as Ian said, our next subject, and I'll try to keep things moving, is the importance of clear plan records to prevent risk for plan sponsors of all sorts of different types of litigation that can come up, especially on older claims when you have records or plan documents that aren't clear. So next slide, please. For the purpose of at least this presentation, there's two types of plan records I'd like to focus on. One are plan documents, and the other is plan records, who's in the plan, what benefits are due to people in the plan. And as I said, there's a significant risk of having litigation or having exposure to potential litigation if there's an unclear plan document or inaccurate plan records, and those can go on, in some cases that we've seen, even for decades. There may have been a bunch of entity mergers in the interim, and it's not clear who has the documents and what the documents said when they existed, and the people who might have had the knowledge might have long left the company. So these older cases where there are unclear records can present risks even years down the line. And it could also have a situation where there was some sort of error that was made 10 years ago, 20 years ago, 40, 30, 50, what have you, where at some point someone realizes there was a record, someone was getting paid benefits who wasn't supposed to be, someone wasn't getting paid benefits who was supposed to be. And then someone comes to retirement age and they're like, oh, I've got some sort of benefit. And then someone says, well, no, you're not entitled to that benefit, or they make a claim and the plan says, no, we're denying that. But they might have had a statement that says, I'm entitled to the benefit that was 30 years old. Or there's some other estimate about a benefit that was 30 years old, and maybe it had a disclaimer language in it, and maybe it didn't have a disclaimer language in it. But there's potential risk, especially if people have relied on long-standing assumptions about what sort of retirement benefits they're entitled to, that can rear their head even many, many years after the fact. Next slide, please. So one example that we saw recently was the Skelton case, that it didn't have quite the same long-term effect or long-term situation, but it was a pretty good example of the importance of having clear records as to who's entitled to what in a given plan. There was an employer that had group life insurance, and they collected all the premiums from employees, deducted them from paychecks, and then sent one check to the insurance company. And there was an employee who wasn't eligible to purchase supplemental insurance, but the employer let her fill out the paperwork and deducted premiums even after she went out on disability leave. There were a couple layers where things got missed. And then the insurance company asked for evidence of insurability, which would have been required in this situation, and that was never provided. But as the court explained the facts anyhow, the company was still deducting premiums, and the insurance company was still accepting the premiums. And then when the employee passed away, there was a claim for life insurance benefits, and the benefits were ultimately denied. And the employer settled for most of the would-be policy limits, and the insurance company was found liable for the rest of them. And a couple key points to take away here are that this was an insured plan. This wasn't self-funded, and the employer still ended up, the plan sponsor still ended up on the hook for a significant portion of the claim on, I mean, it was ultimately a settlement, so it's not clear why any particular decision was made, but the risk, the exposure there was that the employer was deducting premiums, even though the person should never have been approved to get that insurance in the first place. And then from the insurance company's perspective, the problem was that, at least according to the court, that they should have realized they didn't have all of the documents necessary for a valid plan and not accepted premiums, which can be difficult when you have a company that's remitting a group of premiums altogether, but the court ultimately held the insurance company liable too. So the fact that a company has an insured plan doesn't necessarily prevent these breach of fiduciary duty claims, and the fact that an insurance company is just insuring the company and not making any substantive decisions, at least on the determination in the Eighth Circuit and similar case on the Ninth Circuit, there's potential exposure if there's an error made. There's some contrary case law in other circuits, including the Fourth Circuit, but it's important to keep in mind that even a small error like this, the result was that the employee's beneficiary got the full amount of the policy, and the insurance company and the employer ended up on the hook. Next slide, please. Another example that can come up is if an employer record doesn't accurately show an employment status. Let's say someone goes out on disability leave, and under the terms of the plan, that employee is no longer eligible for certain benefits. Or if an employer doesn't show an employee in the correct employment status, and they would be eligible for certain benefits had they been noted in the correct status. And what ends up happening is these errors can potentially go on for a long time, and then someone's either been getting benefits they weren't supposed to or not getting benefits that they were supposed to, and either the company is paying out a lot of money that it wasn't supposed to be, or years down the road, the company is ending up with having a situation where they might have potential litigation risk in defending a claim where most of the people who are involved in the claim and who might have the relevant information aren't there. Another situation which is slightly different is plan documents that have either outdated or contradictory terms for determining benefits. This can happen in a couple of different ways. One is a benefit plan gets amended, or there's a new plan, but it still references back to an old plan. And another fairly common way is that plans get merged as companies get merged, and the benefits never get fully harmonized into a new single plan. And the plan document might reference another document, which cross-references another document. And once you've gone down the rabbit hole, the plan both has to pay something and has to not pay something. And what ends up happening is that whatever answer the plan comes to is the court will often determine to be the wrong answer. So next slide, please. Potential avoidance strategies to avoid all of these issues is one suggestion is regular audits of plan data and making sure that different databases of benefit eligibility, employee status, all are in harmony with each other, making sure that we're converting paper to digital, that everything gets properly converted and that those records match up. For the situation where there are plan cross-references that are contradictory or outdated, it's helpful to make sure to either have a single plan restatement that potentially could incorporate new documents for each program, or having a single plan, maybe a wrap plan, that covers all of the key documents, and then everything can be updated in its own universe without having things that are contradictory. And there's always, as I'm sure everyone on here is aware, the obligation to monitor the actions of other fiduciaries or service providers to make sure that they're doing what they're supposed to be doing under the plan and not creating potential issues down the road, because there's obviously not, there's a cliche, an ounce of prevention is worth a pound of cure, but in this sort of situation, it's really true. A small change at the beginning, even if it's slightly more expensive, can potentially save a significant amount of risk and distress and cost in defending litigation years down the road. And with that, I think we are back to Kathleen. Oh.
Right. Well, we have the CLE code for those of you on the phone and can't see this screen. The CLE code is SS2771. That's SS2771. Everybody note that down. I'm going to just quickly touch on withdrawal liability, PBGC, news from the PBGC. Kate, can you, next slide, please? So we debated about withdrawal liability. It's a fascinating topic. It's very, very expert driven. And but generally, for those of you who may not know about withdrawal liability, ERISA provides that if you're an employer and you're withdrawing from a multi-employer pension plan, you have to pay a share of the future plan's unfunded vested benefits. So looking at 29 U.S.C. 1393A in determining this interest rate for calculating what I'm supposed to pay as an employer who is withdrawing, you're supposed to either use the actuarially assumptions and methods that offer the actuary's best estimate of anticipated experience under the plan, or methods set forth and assumptions set forth by the PBGC regulations. There have been in certain situations, despite the statutory language where you're only supposed to use two different calculations, some plans have attempted to use the pension benefit PBGC's plan termination rate, which is much lower than the rate for expected plan growth, and that will obviously lead to increased amount of withdrawal liability to make up for an employer's unfunded vested benefits. Next slide, please. So in 2022, with some key developments, we had 2 Court of Appeals who actually rejected the plan's use of the PBGC rate. In the decisions, they said it was inconsistent with the requirement that withdrawal liability rate reflect the best estimate of plan experience. The cases are here. I mean, typically the PBGC rate is about 3%. I think I looked in December, it was 5.5. So it came up, but there was such a disparity between the PBGC rate and the best estimate that these courts thought that the plan used the wrong rate. Jules is we're gonna tag team on this one, and Jules is gonna talk about the PBGC proposed regulation, which is the next slide, please.
Sure. So as Kathleen said, ERISA allows 2 different potential calculations for withdrawal liability. One is the best estimate of plan experience. The other is a regulation that the PBGC provides. But until now, there hasn't been any PBGC regulation, so the best estimate has been the only game in town. In October, the PBGC proposed a new regulation that would actually allow plans to use the PBGC plan termination rate without respect to what the best estimate language is and without even considering what actual funding assumptions were under the plan. If this had been in place a year ago, there could have been a pretty significant difference given the gap between expected growth and the low PBGC plan termination rates. That's slightly less of a distinction now, but if the rule gets finalized, there could be a big shift in withdrawal liability calculations and potential withdrawal liability because plans would be able to just use the rate from the PBGC regulations without having to consider actual planned growth expectations. And one related point, as you see on the slide, is that there's the American Rescue Plan provided for payments for certain underfunded plans, and plans who took those payments have a regulatory obligation now to use the PBGC rate for at least 10 plan years. So where we are is that for certain plans, they have to use the PBGC rate. Under the other PBGC rules, they might be allowed to use the PBGC rate, but until the PBGC rate gets finalized, they still have to use an estimate of what's the best estimate of expected plan outcome that actually looks at what the plan assumptions are and what the plan's expected growth is. And with that, we will move on to Ian for the grab bag.
Thanks, Jules and Kathleen. Yeah, so we have a veritable grab bag of other issues to just touch on briefly in our remaining few minutes with you. First is, we didn't flag a particular case, but it continues to be a subject of considerable litigation, mental health parity. The Parity Act requires that mental health benefits be comparable to those provided for other medical and surgical care. We will often see those claims tacked on to ERISA claims for benefits, essentially arguing that the plan at issue has underpaid for mental health treatments. In particular, residential treatments are a subject of a lot of litigation. There's also been ongoing litigation in the welfare plan world about out-of-network medical services, and in particular now, plaintiffs challenging the use of repricing vendors to try and drive down costs or to reduce the amounts that participants may ultimately be on the hook for if the provider balance bills. And we're seeing providers continuing to be very aggressive and creative and trying to stay out of federal court on some of these cases, and having some success, particularly one place where that seems to be working is in New Jersey, where the courts have generally sent those types of claims back to state court when they're removed. we go to the next slide. Years ago, shortly after the ACA was passed, we talked a lot about the ACA's anti-discrimination provisions and mused about whether or not they would actually have any teeth and they'd come into play at all. For a while, they didn't, but there are now two decisions, and soon to be an appellate court decision on one of them, dealing with the application of the ACA anti-discrimination provisions in the context of a gender-affirming care to folks with gender dysphoria. And both cases basically dealt with plans. One case, it's a state Medicare plan, a Medicaid plan rather, and the other is a private insurance plan. But situations where the plan covered certain procedures such as breast reduction or breast augmentation and other surgical procedures in certain instances, but not if the diagnosis giving rise to the need to perform the procedure was gender dysphoria. And in both cases, I would say unsurprisingly for the Western District of Washington, a bit more surprisingly in West Virginia, but both cases had really no problem, or courts had no problem saying gender dysphoria is a diagnosis you only get if you are transgender, and being transgender is a subject on which discrimination can be based on sex, based on the Bostock case from the Supreme Court. And so both cases, the defendant lost on those issues, and as noted, we're going to hear from the Fourth Circuit relatively soon. Next slide. In an effort to just touch on a few areas that we weren't otherwise going to drill in on, we flagged a few cases that are worth a read here. And I just want to highlight two of them. The Walsh case from the Seventh Circuit is kind of a cautionary tale about the Department of Labor and its investigative authority. That case dealt with a third-party administrator for plans and an investigation going on about improper or unauthorized distributions of plan assets. There was argument both about the breadth and scope of the subpoena that was issued by the DOL to a non-fiduciary administrator, but also whether the DOL even had authority to subpoena non-fiduciaries. And the Seventh Circuit pretty much shot down the opposition to the subpoena and said that the DOL has broad authority to subpoena and investigate, use its investigative powers to get information from non-fiduciaries, even if it was going to be very burdensome to comply. In this case, the evidence was thousands of hours, which is easily believable, having dealt with the DOL and DOL subpoenas. So if you get a DOL subpoena, I think the lesson here is get in touch with your ERISA counsel and litigation counsel and come up with a good strategy to oppose it, because you're not likely to get a lot of sympathy from the courts, at least in the Seventh Circuit. The Hawley case out of the Second Circuit is also notable because it's rare to get out of class certification in a defined contribution case. But here, the defendant was successful in vacating a class certification award. The case had to do with the TPA's practices in connection with collateralized 401k, 403b plan loans. And the defendant pointed out that the district court had not delved into the question of whether the defenses defeated the Rule 23 predominance requirement. And the Court of Appeals looked at the issue and said, look, there are defenses here to these prohibited transaction claims that really turn on what did each individual plan do. And that's not something that you necessarily can decide on a class-wide basis. And basically said to the district court, look, you've got to look at this issue. I didn't prejudge it as a win for the defense, but said this is something that needs review. So more to come on that issue, but if you're fighting class certification, that's a good case to look at because it does stress that the court really needs to analyze all of the issues under Rule 23 and look at defenses and how they may affect class certification. So with that, I think that brings us to our conclusion. As Kate said at the beginning, we will send out to the folks on the call confirmation about the CLE code and CLE materials, and then also a copy of the slides. And feel free to email any of us if you have questions that weren't addressed on the call or want to talk about any of this further. With that, thank you very much.
Ian, I think there was one question in the chat repeating the CLE code, which was SS2771, SS2771.
Thank you.
Thank you all.